אורקל נגד גוגל. אישית הייתי מעדיף לדבר באנגלית, אם זה לא מפריע לאף אחד. אז נתחיל. אני מתעסק הרבה באופן סורס, אני חושב שזה חשוב, זה נושא חשוב, זה גם חשוב. I said I would speak in English, right? So yeah, I'll speak in English. It's important for the country, it's important for Israel. And this recent decision of Oracle versus Google is likely to have a lot of effect, a lot of important repercussions for open source. So it's an important decision to talk about. The background of the decision really starts, of the case really starts in 1995 with the invention of Java. So Java was invented by Sun Microsystems, which eventually was bought by Oracle, which is why it's Google against Oracle. And the idea of Java, which I'm sure most people here are familiar with, was that there's lots of platforms. There's lots of platforms that you can write programs for. In 1995, there were IBM PCs, Apple IIe's, Commodores, maybe. There were lots of different platforms. People wanted a way to write a program that would run on any platform. So the idea of Java, which was invented by Sun, was that you wouldn't target the program to the underlying platform or to the operating system. Java, or Sun, would have this virtual machine that would run on top of the operating system, on top of the program, and you could target your program towards the virtual machine rather than to the program that runs underneath it. And the idea of Java was that you would write the program once, you could run it anywhere, on any platform, on any computing device. Fast forward 10 years later to where we are almost today. Android. This idea of the virtual machine was very attractive to Google when it developed Android, because Android is, as almost all of us know, if you don't know, I don't know where you've been, then it's a platform that's supposed to run on almost virtually any kind of mobile device. So the idea of a virtual machine that would allow you to run a program on any device was very attractive to it. So just a little bit of background about Android and the open source components of it. Most of the stack is either GPL. So down here we have the Linux kernel that Android is running on. Most of this is actually not the kernel, but it's Linux. It's all GPL, which Jonathan spoke about. There's a lot of issues about open source on GPL. On top of that, almost everything else is licensed under the Apache license. Over here you have the Android runtime, the libraries, the application framework. On top of that, what most people here would be writing applications rather than the platform. That's all licensed very permissively under the Apache license. And we'll talk about in a few minutes why all of that is licensed very permissively under the Apache license, and why the rest stayed GPL. So again, the runtime, the virtual machine in Java is basically the Java virtual machine, but it's optimized for mobile devices that are constrained by speed and memory. So basically it's Java, but Google changed Java a little bit, just a little bit, not just a little bit, but enough that it's not really interoperable. That if you write a program for Android, you can't be sure that it'll run on any other Java virtual machine. There's problems there with compatibility, and obviously this did not sit very well with Sun or with Oracle, as the case might be, because the whole idea of Java was that you would write the program once and you could run it anywhere. You could run it on any platform. And by developing Android, Google broke that paradigm. So can Google do that? Can it just take the code of Java, take the virtual machine, take the idea of the virtual machine, and make it into Android, transform it into something new? That's what the decision is about. The law that tells us whether Google could do that is the law of intellectual property. There's a lot of issues of intellectual property in the case. There's issues of patents, there's issues of trademarks. The issue that we'll focus on today is the issues of copyright, mostly because they're I think they're the most interesting, and they're the issues that affect the most the world of open source. So as Jonathan said, copyright protects the expression of something. If you have a book, it'll protect the way you wrote it. If you have poetry, it'll protect the rhymes. But it doesn't protect your ideas. It doesn't protect the functionality that you have in the software. And again, going back to Jonathan, as he said, that's problematic for software. Because if you think about what people are doing with software, why people are buying software, what they want, they don't really care about how elegant the software is. Maybe the developer cares, maybe your company cares, but the people that buy the software care a little bit about how elegant it is. They really care about how it works, about the functionality. So when copyright protects the expression, but not the functionality, it's not really protecting what's important in software. And this causes a lot of problems and decisions in in law. And it's really what's fundamentally the issue in this case, that copyright doesn't protect what's important in software. So going back to Android for 1 second, again, at the bottom we had the Linux kernel. On top of that we had the application framework, the libraries. Most of this, none of this is really important for the decision. The only thing that's important for the decision is the virtual machine and the libraries of the virtual machine. And even that is not really important. It's not really an issue in the decision, because Google did a clean room implementation of that. They wrote it all from scratch. And the only thing that's at issue is the interface, the API, the interface between the virtual machine and the applications that run on the virtual machine. That's what Google copied. So one more sec, to dive a little bit deeper into the code of what that means. And again, when we talk about copyright, we're talking about the expression. So we always have to look at the code. What did they copy? What words did they copy? What functions did they copy? So here is the Java source code implementation of one method in Java, of the method maximum, max in Java, which you put in two numbers, 3, 5. If you put in max 3 and max 5, max 3, 5, it'll give you at 5. That's the method. Here is, on the left side, the implementation of that method. So the only thing that we're really concerned about is the header. The header. Most of the bottom, the implementation we won't look at for a sec, we won't look at. If you look at the header, again, max works that you put in two floating numbers, float 1 and float 2. Then after that, there's max, which is the name of the method. Going a little to the left again, you have float. So if you put in two floating numbers, you use the method max, you'll get out a floating number, and then it's a public static function which describes how it interacts with the rest of the API. So that is the header function for the Oracle implementation of Java. Now if you look at the Android implementation of it, it's almost completely different. It's max, it's the same number. And the implementation is almost completely different. If we put them side by side, you can see that the implementation at the bottom is not the same at all. The only thing that's the same, the only thing that Google copied, is the API, the header. If we look at it's a little slow. If you look at the headers that Google copied, Google in the original Oracle header file described how the method worked. Put in two floating numbers. You use the method max. You get out a floating number. Google wrote the same header file, but the rest, the implementation was completely different. They didn't copy the rest of the implementation at all. Why did they do this? And it's important to, we'll get back to that for a second. So not only did Google copy, this is only one method. This is only one method of Java. And it's only one method in the class of math. I think there's something like 50 methods in that class. Max, in the class math. So they copied all the methods, all the header files of the methods, again, none of the implementations. And in the class math is only one class in the package Java lang. And again, they copied all the header files of all of these classes, but none of the implementations. And the package Java lang is only one package of 37 packages that Google copied. So again, Google copied 37 packages, all the classes in those packages, all the methods in those packages, the whole organization of those APIs, how they interrelate, the error files, how they relate to one another, but again, only the header files, none of the implementation code of those packages. So, can they do that? Before we get to that question of can they do that legally, let's talk about why they did it. The reason they did it is because if you think about the Android and its main competition, the iPhone, back when these were introduced, the iPhone had a very large head start. And a head start in the sense that developers were developing lots of applications for the iPhone, and there really weren't, Google wanted to encourage the very quick development of applications for Android. And they needed a way to encourage developers to develop that quickly, and the way to do it, the way they thought of doing it, there were a number of ways, but one of the ways was to give them a very familiar way of developing. They would give them, they'd say, just develop in Java, you're already very familiar with it, you can develop applications for us. And again, it wasn't exactly Java, it was a little different, this didn't make Oracle very happy, but it really encouraged the developers, and they quickly got a very large number of applications. Did they have any options? Did Google have any options? Aside from just taking it, they had a lot of options. They could have gotten a commercial license. They could have paid Oracle to take the header files of Java. Why did they do it? Because they would have had to pay it. You know, if you think about 5-6 years ago, Google's giving away Android for free. They don't know if they're going to make any money out of it. They still don't make any money directly out of it, but they make money out of search and other applications. So they didn't want to pay Oracle for the license. They could have gotten a specification license, which is a little different. A specification license means you don't get the license to all of Java, you just get the license to use the header files, and Oracle had this idea that you could get a license just to the header files because there were companies that wanted to implement Java for specific environments. I think IBM took a license like that. Why didn't they do that? This is exactly what they needed. Why didn't they do that? Because the license that Oracle was willing to give said Google could not subset or superset Java, which means basically if you take the license, you can use the specifications, you can use the header files, but you can't change them, you can't make them broader, you can't take off header files. Why can't you? Because again, what was important to Oracle was that if you write the Java program once, for any platform, it will run on any platform. And Google didn't want to do that. They wanted to change it. They wanted to make it more optimized for mobile systems, and therefore this option wasn't good for them. Another option, which Google had, was that they bought Android in 2005. By 2006, 2007, Java was available under the general public license, under the GPL. So Google could have taken all the source code of Java and just used it under the terms of the GPL. Why didn't they do that? And this would have solved a lot of problems that Google had because Oracle had a lot of patents on Java. If you take a license under the GPL, the person that's giving you the license is basically saying, I won't sue you under any of my patents at all, either. So why didn't they do this? The reason they didn't do this is because they were scared. They wanted developers. The reason they wanted to use Java was because they wanted developers to quickly implement a lot of applications for the platform. And if developers had to start thinking about the GPL, about their GPL obligations, whether they had to disclose source code, then this would have slowed down the development of all of those applications. Personally, I don't think that there's really an issue there, which is a problem. Developers, I don't think, would have had to disclose the source code. But Google didn't want the developers to even think about it. There was some inherent fear of the GPL. They didn't want to think about it. So Google didn't take any of these options, and they just took it. They just took the header files. Can they do that? The case was in California, so it's a California case. And I took some quotes from the case. I don't think it's really worth reading them in any detail, but basically the judge said Google could do it, because why? Because those header files, the header lines really describe what the idea of the program is, the idea of the implementation, the idea of the method. You put in two floating numbers, you get a floating number out, the maximum of the two. That's just the idea of the function. It's not the expression. It's not the poetry of it. It's just the way it works. That's what the judge said. And again, we have a situation here where copyright is not protecting what's important about the software. Because what's important about, to Oracle at least, was the APIs. They didn't want someone to just take all the APIs, run if they create something new, and not pay them any money, and they couldn't protect that, at least according to this judge. The case is still under appeal, so this is just interim. The next judge could say something completely different. I'm not sure if the decision is right, but that's what it is. So, is this good for open source software? And the answer, I think, is yes, but you have to think about it a little bit deeper than just yes. Because, well, first of all, I think it's good because Android is open source. Android is now basically free of its, not completely free of legal problems, but more or less. And it allows Google to continue developing and distributing the Android platform. It also, I think, had a psychological boost to the open source community because it gave this impression that now software is freer. You can take code, you can take APIs and do a lot of things with them that maybe there was some legal fear about before. In addition, many projects depend on open APIs. Most importantly, I think, is Linux, which depends on, right? Linux is basically just another implementation of Unix APIs that were developed by AT&T, who knows, in the Stone Age. And if Linux, and if AT&T had a copyright on those APIs, then Linux would have legal exposure. Samba is another project which lets Unix servers talk with Microsoft servers, basically. It's based on a Microsoft protocol. They're basically implementing that protocol, that API. So if there were legal problems with that, then that project would have a lot of legal problems as well. Aside from that, there's just, you can list a lot of programs, a lot of open source projects that depend on the re-implementation of existing APIs. So here's a list at the bottom. That's the yes, and now comes the but. The but is that open source really needs copyright. If you're going to write an open source program, if you're going to license it under an open source license, the only way to do that is with copyright law. Proprietary programs that are not open source, have a lot of ways of protecting them. They don't need copyright law. You can protect them with copyright, but you can also protect them with trade secrets. Just don't give anyone the source code. It's hard to figure it out. You're basically done. You can protect it with patents. You can protect it with digital rights management. So there's a lot of ways to do it. They don't really need the copyright. But open source, the legal basis of open source is really copyright law. It's what allows an open source license to say, I'm going to give you the program, you can use it, but only if you mention that it's under my name. I'll give it to you, but you can use it, but only if there's no warranties. It's what allows the GPL to say, you have to keep the program free, and you also have to disclose the source code. That's the legal basis of all of these licenses, and the more you weaken copyright, it becomes unclear of how much these licenses have force. Another thing is that if you're writing a program, you have a choice. You can protect it with copyright, which you protect it by copyright anyways. You can also go a step farther and protect it with patents. And a lot of economists think that the weaker that copyright gets, the more people protect programs with patents. If you're Microsoft and you understand that copyright doesn't give you that much protection, you're going to go out and write patents on your programs. And that's basically what happened. Here's a graph of software patents and how much those have increased in the past 20-something years. And as you see, there's really a great increase. And part of the reason for that increase, a lot of economists think, is because over that period, copyright has gotten weaker. Copyright for software started off very strong, and over time it's gotten weaker slowly. And that's why people have really increased their patenting of programs. And finally, it's I think another concern that this case raises is the issue of permissive licensing, like the Apache license, like BSD and MIT licenses, versus the GPL, which are more restrictive licenses. And something that you see in this whole story is that people are afraid of the GPL. That's the reason why Google didn't want to release Android under the GPL, even though it would have solved a lot of their legal problems. It would have solved all of their patent infringement suits, which they spent billions, tens of millions even, of dollars defending. So it's good. Apache, if you license, you have to think, when you think about licensing, it's not only what you want to do, but it's the effect, the economic effect, the broader community effect that these licenses have. So if you license something more permissively, as Google did, it encourages broader community participation. So Google really developed a really strong community around Android, around the developers, mostly because it licensed Android permissively. OpenStack, the cloud platform, that's really why it's licensed under Apache permissively, because they really want to encourage broad communal participation. But this, in some sense, reflects a fear, perhaps a reasonable fear of your GPL obligations. And GPL has a lot of important points to it. We're not talking about the specific program that you're licensing. We're talking about broader community issues. If you license something permissively, there's a large risk, not a large, but there's a risk that people will take it, that people will take it in different directions, that the community will fork. Someone will take it one way, another person will take it another way. Android has some problems with forking. Every device, every hardware manufacturer implements it a little differently, have different customizations. This creates problems it solves a little bit of problems for Android developers. The GPL projects tend not to fork. Linux has never forked it, or permanently. There have been temporary forks, but in the end, the community always came back together to the same code base. Some things licensed under the GPL, they tend not to fork because everyone has to share their improvements. The fact that the community is moving farther towards Apache is, in the sense, somewhat problematic for developers. It would perhaps be better if these projects did not fork. And another thing that that should be understood about Apache licenses is that it allows anyone to take that code and say, okay, thank you very much for the code. We're running off and we're selling it under our own license. We're not keeping any of our improvements. We're not giving you any of our improvements. We're keeping it for ourselves. Apache allows you to do that. That is not yet a problem with Android or OpenStack, but there are hints of it. It could be. Who knows? Only time will tell.
It's already a problem because some vendor provide you OpenStack, which is not yet open source.
So I finished. Thank you very much. Questions, which we have already.
שמי עמי. ההבדל בין אפאצ'י ל-GPL למי כל אחד טוב. אפאצ'י טוב לספקים, ה-GPL טוב ללקוחות. כלומר, יכול להיות באופנסטאק, זה כבר קורה באופנסטאק וגם קורה באדו בדרך אגב. מי שרוצה להשתמש, כדאי לו שישים לב, שהוא לא מקבל, חושב שהוא מקבל מוצר אופנסטאק, הוא מקבל מוצר שהוא למעשה פרופייטר. כל מי שפוקח את המוצרים, חייב לשים לב, לכן ההסתכלות היא מאוד מאוד שונה. יש לי עוד שאלה אחת אליך. יש גם פסק דין במשפטי של האיחוד האירופי בנושא זה ש-API לעשות עליו כמו פסק דין האמריקאי. מה?
זה הפסק דין, הוא התחיל בבריטניה, שפסק.
השאלה האם יש פסקי דין שונים בארצות הברית
באמת, אותו פסק דין שיונתן דיבר עליו. אותו רעיון פחות או יותר. שה-API the API doesn't protect the functionality, the copyright doesn't protect the functionality of a program. The Google case is much more detailed. It gives you more detail about what exactly that means, not protecting the functionality. Here is an API specific example. This last case is a little bit more general. It doesn't really get into that many details. It's hard to know how to implement it. In general, I don't like European decisions for that reason. But any other questions?
Hi, so two questions. First of all, OpenJDK is not strictly licensed under the GPL. It's a weaker form of the GPL. It's a GPL with a class path exception, which is similar to the LGPL, which means that apps written by developers do not have to be open source, but the implementation itself does have to be, which means that licensing under the Apache licenses, as was said, better for the distributors of the Android platforms, or the variants of the Android platforms, and not for the developers. So that's one question, is why didn't they go that way? And the other question is, I know this is copyright law and not patent law, but for example, the max function, isn't there anything about copyright like which says, well, this is trivial. This has been how mathematicians have been doing it for hundreds of years, and you can't copyright that?
So 2 questions. First of all, the license of Java, which it's true that Java standard edition is under the GPL plus the class path exception, and the history here is very confusing, but it's not true about the mobile edition of Java. The mobile edition of Java is under the regular GPL without the class path exception. And there's a good reason for that, exactly because of this, because Oracle didn't want someone, because Oracle knew that mobile would be the next big thing, they didn't want someone to take Java and license it under, take it and really run, take it and make a platform where people could develop applications for it without paying them for it, without paying them for a commercial license. So then the question becomes, how different is Java standard edition? How different is the mobile edition? Could you take the standard edition and make it, use it for, could Google have taken it and using it for the Android platform? I think this is, it starts to get complicated, and these are really going into Google business decisions. That's the answer for that question. The second question was is it possible really to protect something called Max? Is it just the way people have done this for years? Can it be protected by copyright or patents? Protecting it by copyright or patents are very different ideas. Patents, you probably couldn't protect something as simple as Max, but maybe you could protect something more complicated. You could protect something. You know, I just took a very simple example for illustration. You could pick something more complicated. Maybe you could protect how the whole API interacts with each other. But just Max is probably hard to protect. Thank you.